The federal judge will decide in the coming months whether Hunter Biden should be sentenced to prison. The 3 felony counts he was convicted on carry up to 25 years behind bars. To discuss this and other related topics, I want to bring in former Deputy Assistant Attorney General Tom Dupree. Tom, I want to play you some sound from a statement that David Weiss, the special counsel, made after the jury delivered its verdict. Let's take a quick listen to that.
This case was not just about addiction, a disease that haunts families across the United States, including Hunter Biden's family. This case was about the illegal choices defendant made while in the throes of addiction, his choice to lie on a government form when he bought a gun, and the choice to then possess that gun. It was these choices and the combination of guns and drugs that made his conduct dangerous.
Tom, evaluate that statement. Is it typical for special prosecutors to make statements such as this after a verdict?
Well, yes and no. In high-profile cases, it is common and appropriate, I think, for prosecutors to make these types of cases. What's a little bit unusual was that the prosecutor did highlight what was really an underlying theme of their entire presentation to the jury, that they weren't looking to punish Hunter Biden for being an addict, because they knew quite well that many of the jurors had people, close family members, who themselves had struggled with addiction. Instead, what the prosecutor made clear is that this is a case about choices. Poor choices, unlawful choices that Hunter Biden made while in the throes of addiction. So I thought it was a very thoughtful distinction, and one that was very consistent with the way that the prosecutors tried this case.
And those choices, Tom, how will they factor into judgments made about sentencing?
Right. The judge is going to take a number of things into account at sentencing. One thing she'll take into account, of course, is that Hunter Biden is a first-time offender, which will counsel in favor of a lower sentence. She'll also take into account the fact that the gun issue was not used to commit a crime of violence, which also would counsel in favor of a lower sentence. Although the judge has discretion to sentence him to a fairly significant period of time, 10 years, maybe even more, I can't imagine she would go anywhere close to that. My best guess, Major, is that she is going to come in at a lower number, maybe a year, plus or minus, of incarceration. That's my best guess of where she's going to go with this, a sentence at the lower end of what the guidelines allow.
Tom, you remember as well as I do, and some in our audience may remember, about a year ago, there was a whole different orientation to the underlying facts of this. There was a recommendation that came from prosecutors and the defense attorneys for Hunter Biden for a diversion program about this underlying set of facts. When the judge, the same judge who heard this case, intervened and said, wait a minute, I'm not comfortable with that. That's not a proper application as I understand the law. How do we view all of that in retrospect now?
Well, I can tell you, I'm sure the defense team looks back at those halcyon days where they thought they had a deal on the table, only to see it pulled away at the last minute, like Lucy pulling the football away from Charlie Brown. They had a sweetheart deal, in my opinion, now to have enabled Hunter Biden to pull a lot of these charges to rest. As you note, the district judge did her job. She kicked the tires on the plea deal. She asked tough, probing questions of both sides. And she ultimately ferreted out the fact that there wasn't really a deal on the table, that both sides had a different understanding of the terms of the deal. And so it basically blew up on the launch pad and led to today's conviction.
And when I mentioned in my open, Tom, about the power that justices have over evidence and procedure and things like that, she exercised it from your vantage point properly.
I do. I thought this was a very tightly run trial. We didn't have a lot of the drama and histrionics that sometimes attaches to trials that have a political hue to them. It seemed like the jury was well instructed. The jury certainly deliberated in a very efficient fashion. We didn't seem to get any sense of juror confusion or puzzlement. To the contrary, the jury seemed to approach its job very thoughtfully, seriously, deliberately. They initially were split on the verdict, but ultimately they were able to reach a unanimous verdict. All of that speaks well to the way that the judge presided over this trial.
Tom, as you know, everyone convicted has the right of appeal, but not all appeals are created equally. Do you see grounds for appeal on this that have validity or potential validity?
Well, Sure. I think one of the most tantalizing arguments here on appeal, Major, is a Second Amendment argument. Hunter Biden's defense lawyers, I expect, are going to argue that at least some of these charges basically violated his Second Amendment rights, the constitutional right to bear arms. There are some courts in the country, in Texas and elsewhere, that have actually held that these statutes violate the Second Amendment. It's not entirely clear if the federal appeals court that supervises cases coming up from Delaware will reach the same conclusion, but it's a serious argument, a serious issue, and we can expect a battle royale to be joined on appeal in about 6 months to a year.